How well are we served by our Constitution? In recent months, this question has been raised from individuals concerned with our rights and how well they stand protected under the Liberal government. Worries emerged even months after Mr. Trudeau took power. And the reason? A legal case, rarely discussed in public, that set the precedent for his office's use of power from 2015 to the day he called this current election. Let's look at this neglected legal affair and examine this government's actions in the light of the Constitution and our rights and freedoms. In 2015, Mr. Trudeau reviewed contracts from the previous government and wanted to reverse the construction contract with the Quebec Davie shipyard, already engaged in building a supply ship. Although rumors flew around Ottawa that the contract was in jeopardy, the government focused suspicions on Admiral Mark Norman as having leaked details of the affair. In January 2017, Admiral Norman was relieved of duties, and in March 2018 he was charged. The procedure stretched on for months owing to the government's refusal to share sensitive documents concerning the case with Norman's defense team. In May 2019, the charges were stayed at the prosecution's request, since they could not fully prove a criminal breach of trust had taken place. Admiral Norman retired from the Navy and received an apology backed by most members of the House. It was apparent that the government's wish to pursue the case was blunted by documents from former Conservative government cabinet ministers and even one important Liberal MP who vouched for the Admiral's conduct in all things military. What's interesting here is how the Liberal government used confidentiality of cabinet and government documents to their own ends. This practice has been repeated over and over in ever-widening issues of government business and state control. When opposition leader Erin O'Toole brought up the Norman affair in Parliament, Liberal parliamentary secretaries tried to shut the discussion down, citing rules that discouraged deliberations of matters before the court. Later on, in Admiral Norman's comments to the press, he pointed to, in his words, an alarming and protracted bias of perceived guilt across the government. How could this government's handling of the Norman case be such an affront to the Constitution? Well, because the government can act in its own interests when it comes to privileged information. How this power has spiraled out of control from an isolated legal process to an overall limitation on how Parliament may conduct its own affairs is a story of weighty proportions. First, the right to speedy trial. The Supreme Court says a trial over 18 months from the date of charging to its conclusion is excessive. The prosecutor in this situation gave up the case after 15 months. And here is the conflicted side of the issue. The state prosecutor could not proceed with a timely case because the government refused to bring the papers to court. Thus, the right to speedy trial can be blocked by the state's interest concerning those materials brought to the court. Indeed, this protracted bias, as the Admiral mentioned, not only affected him in the court proceeding, but notably in his being held under suspicion for over a year, even before the charges were ever laid. Secondly, the right to the security of the person. The protracted bias of the government did take a toll on Admiral Norman's home and family, especially in financial terms. Being removed from work, paying for legal fees, leads to psychological stress, which is a violation against the security of the person in the Constitution. Canada's Supreme Court brought up this question about a similarly protracted case years before, and though no harm in that procedure was found, it did establish that the security of the person is a legal right and an important factor in court hearings. In the Norman case, the fact that the government could defy the defense attorney, and even the judge as well, by not sending important files to the court, could be viewed as a self-serving obstruction that had an impact on the defendant. Thirdly, the right to be considered innocent before trial. While Liberals complained of the opposition MPs in Parliament discussing a real case that was before the court, Justin Trudeau had already cast aspersions on Admiral Norman's character before the charges were even laid. Now, how could a citizen be guaranteed a fair trial if the leader of the country has already judged him suspicious and potentially culpable? Yet nothing could be done since the government held all the vital information and seemed satisfied with charging the admiral 14 months after the issues were raised. Now, this reliance on confidentiality on the part of the Liberal government has been used again and again in further controversies, often with the same Trudeau bureaucrats that were involved in the Norman affair. The S&C debacle was a scandal where the Minister of Justice was unable to build a strong case of Trudeau's improper meddling in a court trial because the cabinet refused to bring its papers under public scrutiny. This insistence on state privilege rendered the constitutional mandate of the rule of law and an independent judiciary practically null and void, especially where freedoms of the courts to operate without intervention are under threat. This practice was then repeated with the Wee scandal. Here, sensitive papers were withheld and then blacked out before submissions to a parliamentary committee were allowed. And yet, the most outrageous incident by far was the government's refusal to surrender documents to Parliament on the activities of the Chinese workers based at the National Microbiology Lab in Winnipeg. Here, the Public Health Agency was blocked by a decision of the Minister of Justice not to disclose anything on the issue simply because of matters of national security and international diplomacy. The result was a ruling by Parliament against the government to surrender that potentially explosive material in the public interest. And then a Liberal counterclaim lodged in the courts against the Speaker of Parliament for attempting to undermine the authority of the Liberal government itself. It is believed by some that Mr. Trudeau called this 2021 election in order to avoid the confrontation before the courts of this issue between the power of government and the authority and rights of Parliament. Not long after the writ was dropped, the government also dropped its case. Thus, we are now in an election not as a mandate for a Liberal majority per se, but perhaps as a justification on how Liberals view their exercise of power. We have seen the ever-widening privilege of the current government in using its power first to attack a private citizen and then undermine the authority of a minister and our courts, and then to impede the work of government councils, and finally to reject the authority of Parliament itself. So, here are the questions. Is a government obliged to act in good faith in our courts and in Parliament so that fairness and our rights to justice are respected? Does the fact that the government is privy to certain information give it special powers to intervene where it should not go and avoid responsibilities when it should act? If knowledge is really power, as they say, how does this make our current government more secure in its secrets than we are in our rights as citizens and in institutions? Are our rights and beliefs de facto points of law, or merely conventions that can be ignored or even sidestepped for the sake of political expediency? The answer was given during the Norman affair in that debate by the opposition leader in Parliament, who said, "No rule can trump a member's privileges in the House." And so, by extension, no government administrative law should supersede the constitutional rights of individuals or even frustrate the rule of law itself. Mr. Trudeau's store of secrets should not be an extension of his privilege to govern. We must seriously think on whether this brand of government truly represents us as the electorate. Thank you for listening.